Welcome everybody, we'll get started. I'm Melissa Castan, Director of the Castan Centre for Human Rights Law here at Monash University. Thanks everybody for joining us here today, and a special welcome to all of those people who've indicated their support for this webinar and for the treaty processes. And I want to particularly welcome the members of the judiciary and the courts, commissioners, members of the public and the private sectors, and particularly and especially the traditional owners and all Aboriginal and Torres Strait Islander peoples and members from the First Peoples Assembly who are joining us on the webinar. I want to start today by acknowledging the Bunurong and Wurundjeri Woiwurrung peoples of the Eastern Kulin Nations, who are the traditional owners and custodians of the lands from where we are meeting you here today. And we pay respect to their elders, past and present. We acknowledge those people's continuing relationship today to the land and waters and to their law and their continuing fight for justice in this country. And I would like to observe that as teachers and educators and the holders of law here at Monash, we have an important role to play in addressing the dispossession caused and the continuing impact of Captain Cook's law across Australia and in Victoria. And we support the Victorian treaty process and those other processes around Australia. It's now over 30 years since the High Court handed down the important judgment in the Mabo case, and it's over 25 years since the Bringing Them Home report was delivered by Sir Ronald Wilson and Professor Mick Dodson. And these are just two key steps in a national journey from that Captain Cook's law to the restoration of proper legal relations with First Nations and the settler state of Australia. And I look forward to this next step in that journey, the passage of the Statewide Treaty Bill and the implementation of a treaty and treaties for Victoria. And I hope all of us here as members of the legal, human rights and education communities and as advocates and experts can contribute actively and intentionally to the political and legal reform that we see before us now. So we are recording this webinar, and we will turn now to introduce our speakers. We hope to have an opportunity at the end of their presentations for some questions and answers, and I'll give you a few further instructions then about how we do that, but we'll be using the Q&A function of the Zoom Zoom platform. And I'm very happy now to introduce my colleague, Professor Luke Beck, who works with me here at Monash University. Luke is the convener of the Victorian chapter of the Australian Association of Constitutional Law, and together we are bringing this webinar to you. So I think, Luke, it's over to you.
Thank you very much, Melissa. And on behalf of the Australian Association of Constitutional Law, our thanks to the Castan Centre for Human Rights Law at Monash for collaborating with us for this very important webinar. I'm delighted to be able to introduce our three wonderful speakers this afternoon. Our first speaker is Professor Cheryl Saunders, AO of the Melbourne Law School. Cheryl has specialist interests in Australian and comparative public law, including comparative constitutional law and method. She's President Emeritus of the International Association of Constitutional Law, a former President of the International Association of Centres for Federal Studies, a former President of the Administrative Review Council of Australia, as well as being a Senior Technical Advisor to the Constitution Building Program of the International IDEA. Cheryl will be talking to us about the structure of the Statewide Treaty Bill. Our second speaker is Associate Professor Harry Hobbs. Harry Hobbs is an Associate Professor in the Faculty of Law and Justice at the University of New South Wales, and his primary research interests are in public law and the rights of Indigenous people. He holds an ARC Discovery Early Career Research Award, where he's investigating Indigenous state treaty making in Canada and Aotearoa, New Zealand, to identify lessons for modern treaty making processes in Australia. He's written widely on treaty in leading Australian and international journals, as well as more broadly on constitutional law, legal reform, human rights, transitional justice, and international criminal law. Our final speaker is Reuben Berg of the First Peoples Assembly of Victoria. Reuben is a proud Gunditjmara man and co-chair of the First Peoples Assembly of Victoria. He sits on the Assembly representing the Eastern Maar Aboriginal Corporation, which is a traditional owner group of southwestern Victoria. The country and waters of the Eastern Maar stretch to Ararat and encompass Warrnambool, Port Fairy, and areas of the Great Ocean Road. He has strong connections to the Hopland Falls area and the Framlingham Aboriginal community. As an elected co-chair of the Assembly, Reuben plays a pivotal role in representing diverse voices and aspirations of First National communities across Victoria. With a deep commitment to advancing the rights and interests of First Nations people, Reuben's a passionate advocate about ensuring treaty delivers for Aboriginal communities the power and tools to develop and deliver practical solutions at the local level. So with those introductions, it's now my pleasure to hand over to our first speaker, Professor Cheryl Saunders, AO.
That work? Yes. Thanks very much, Luke, and thank you, Melissa. Let me also begin by acknowledging that I'm participating in this webinar from the traditional unceded lands of the Boon Wurrung people of the Kulin Nation, and I pay my respects to their elders, past and present, and to other First Peoples participating in this webinar. And given the context, I also acknowledge the First Peoples of Victoria as a whole, who've collectively partnered with the state to lead us to the point where a statewide treaty bill is being debated in the Victorian Parliament. This is an extraordinary and visionary achievement, made all the more remarkable by the novelty of the context in which it's occurred and the originality of the process that's been followed. So my role, as I understand it, is to set the scene for the other panellists by reflecting on this initial statewide treaty and its implementing legislation from the standpoint of governance in Victoria. Victorian treaty process has been underway since 2016. In the early years, much of the focus was on the Indigenous treaty partner, how to forge a collective entity of First Peoples across Victoria that could effectively participate as partner in a treaty process and be accepted as legitimate for the purpose. The success of that endeavour is a remarkable story in its own right. A few years later, however, as the treaty process advanced, I was participating in a conference on it, organised by none other than Harry Hobbs, the next speaker. My focus in this conference was on the other non-Indigenous treaty partner, which it seemed to me had received insufficient attention. And I was curious about three things in particular. First, presumably the treaty would be made in the name of the state of Victoria, but who exactly would act for the state? The government? The Parliament? To what extent, if at all, would the people of Victoria be involved? Secondly, what form would a treaty take? An exercise of executive power? Legislation of some kind, and if so, doing what? Would there be a link with the state constitution? And finally, what would the treaty provide in this modern day context? How would or could it take account of the vast range of governmental activities, the different interests of First Peoples across the state, the complexity of contemporary governance with multiple requirements for accountability, and the potential relevance of Commonwealth law and funding? Well, we now know the answer to all those questions, and they've transcended most of the difficulties with which I was grappling at that early stage, typically in ways that hadn't occurred to me. As so often, much of the success that has been achieved is attributable to the processes that have been followed. The sheer length of the process has contributed to building the trust, mutual understanding, and experience necessary for demanding negotiations of this kind. The process has usefully spanned 2 elections for both the Victorian Parliament and the First Peoples Assembly, further underpinning broad ownership of the outcomes. The process progressively laid effective groundwork for treaty negotiations and agreement in, for example, the establishment of the First Peoples Assembly, the creation of an independent treaty authority to oversee negotiations, agreement on a treaty negotiation framework, and implementation of a truth-telling process under the auspices of the Yoorrook Justice Commission. Milestones along the way, including the passage of 2 earlier and critical pieces of legislation, provided memorable occasions which now have become precedents that brought together Indigenous leaders and elected parliamentarians in the forum of the Parliament. This focus on process also extends to the future. Critically, in particular, it includes the following. There will be an appropriate ceremony at the time when the treaty is brought into effect to mark the high significance of the occasion. There is highly desirable but too often overlooked emphasis on the effectiveness of implementation of the treaty over time. And there are mechanisms for the making of further treaties, some of which are foreshadowed as additional statewide treaties and may potentially include other partners, including, where appropriate, the Commonwealth, and some would be regionally based as traditional owner treaties. And so to my earlier questions. First, what legal form would the treaty take? The treaty itself will be executed by the government on behalf of the state of Victoria. To that extent, it's an exercise of executive power to enter into a compact or contract, the character and high significance of which is indicated by the terminology of treaty. But the treaty is designed to be implemented into law by the Statewide Treaty Act 2025 when it passes on the Parliament. It will build on the earlier treaty legislation, which also largely remains in force. The Act gives legislative form to commitments in the treaty where that is required. It also provides the structure, stability, and predictability that legislation typically offers. Accordingly, the first of the objects of the Act, set out in Clause 2, is to give effect to the first statewide treaty. Appropriately, however, the treaty is not otherwise dependent on the Act. It makes mutual commitments and stands in its own right. I note in passing that the use of legislation also means that the second reading speech on the bill is accompanied by a detailed statement of compatibility with the Victorian Charter of Rights and Responsibilities. This statement canvasses a range of rights issues potentially raised by the bill, including, for example, equality, taking part in public life and privacy in an authoritative and helpful way. The treaty does not directly engage the Constitution, although it is consistent with the recognition of, quotes, Aboriginal people, close quotes, for which Section 1A of the Victorian Constitution has provided since 2004. My second question was, who are the key actors for the state as treaty partner? Now, in a sense, the answers to this follow from what I've said already. The government has been the lead actor in initiation, design, and negotiation, as you would expect from the executive branch. Ultimately, it will sign the treaty. But the Parliament is also a key player, both through its involvement in earlier stages of the process and in the enactment of the current legislation to give effect to the treaty. And there are grounds on which to claim that the people of Victoria also are engaged by the treaty and entitled to feel both ownership of it and pride in it. Treaty has been on the public agenda for a decade, spanning election cycles. Truth-telling under the auspices of Europe gave it an even more public face. And the treaty itself is made in the name of all Victorians, who are invited to embrace the opportunities that it offers to be, and I quote, part of a shared future grounded in justice, understanding, and unity. And then finally, the $64,000 question, what does the treaty and the supporting legislation provide? One answer is a lot. The bill is 246 pages in length, and the treaty itself comprises 34 pages. It's impossible to canvass the substance in detail here. But let me identify what I consider to be the key features which others can develop further. First, as a preliminary observation, the treaty and supporting legislation are foundational in the sense of literally providing the foundation for a new and continuing relationship between First Peoples and the state on which later treaties are intended to build. This foundation confronts the notorious gaps in the Australian story and the legacies of them as bitterly experienced by First Peoples. It reimagines the ways in which state authority might be used in the relationship with First Peoples, and it makes room for, facilitates, and values self-determination. To these ends, it does at least the following. First, it frankly acknowledges the past and sets aspirations for the future in preambles to both the treaty and the bill. Both are worth reading if you read nothing else. Secondly, the treaty framework provides the institutional framework for self-determination. The totality is to be known as Gellung Warl, drawing on Nyerna Yoorrook Telkuna language. It will have legal personality with all that implies. The legislation effectively re-establishes and further empowers what until now has been the First Peoples Assembly of Victoria as the democratically elected principal decision-making body of Gellung Warl. Also within Gellung Warl is the Nginma Ngainga Wara from Wara language, established as a mechanism to ensure the accountability of state institutions in meeting their commitments towards First Peoples. In that sense, it has practical relevance for the state's performance in closing the gap. And a third institution is the Nyerna Yoorrook Telkuna from Wemba language to lead ongoing truth-telling and associated processes across Victoria, including reconciliation and understanding of local history and place. Gellung Warl is answerable to the First Peoples of Victoria, not the institutions of the state. But it is subject to particular state mechanisms and procedures, including, for example, the Victorian Charter, the Ombudsman, the Auditor General, and IBAC. A notable feature of the bill is the fine line it treads between structuring the institutions of Gellung Warl appropriately as instruments for self-determination with culturally appropriate procedures and accommodating them within the system of government of the state under the overarching Commonwealth and state constitutions. Third, the treaty and associated legislation creates a systemic relationship between Gellung Warl and key institutions of the state crafted to achieve the objects of the treaty. For example, the Assembly will provide a yearly address to a joint sitting of the Parliament. It also is entitled to be given notice of new legislation. Bills will require a statement of compatibility with key aspects of the treaty and of whether there has been consultation with the First Peoples Assembly. In addition, systemic provision is made for regular meetings of various kinds between the Assembly on the one hand and Cabinet, ministers, secretaries, and the Commissioner of Police on the other and separately. And finally, provision is made for submissions to ministers and other public bodies by the Assembly with an obligation to comply, and for ministers to seek advice from the Assembly. Fourth key provisions of the bill, if you like, is it sets out key principles on which these relationships rely in terms of, for example, trust and mutual respect and understanding. And it seeks to design and implement procedures through which these principles are realised. For the most part, the scheme does not rely on coercive mandates, leaving the legal authority of the Parliament intact. So, for example, while the bill details a respectful and deliberative procedure for amendments that would affect its fundamentals, failure to comply with the procedure would not affect its legal validity as opposed to its political morality of any legislation eventually passed. Fifth point, the bill includes a special appropriation of infrastructure funds for the purposes of the treaty and provides accountability procedures for their use and regular opportunities to revise their level. And finally, the treaty and the bill contribute towards setting what might be called the broad context for the new relationship between First Peoples and the state of Victoria. To this end, for example, it empowers the Assembly to make Indigenous appointments to key bodies, including the Aboriginal Heritage Council and the Heritage Council of Victoria. In these and a host of other ways, it lays the foundation for the regular and recognised involvement of First Peoples in the symbolic and lived life of the state. Now, I'm sure that there's much that I've omitted or at least failed to emphasise adequately, and I look forward to the observations of Ruben and Harry. Thank you.
Thank you so much, Cheryl, for that very clear overview of the legislation. I'm delighted now to hand over to our second speaker, Harry Hobbs.
Thanks, Luke. Thanks, Cheryl. And also thank you to Melissa and Luke, obviously, for organising this webinar. I'd too like to begin by acknowledging and paying my respects to the traditional owners. I'm coming from Marrickville here in Sydney, so the owners are the Gadigal people of the Eora Nation. Today I've been asked to speak a little bit about how this treaty compares internationally and provide some comments on comparative Indigenous assemblies as well if there's time. And of course, happy to see how we go and do that more in the Q&A if we'd like to at the end. I suppose I've always been struck by thinking about this work and obviously the work that Ruben's been doing the last 4 years, terrific amount of work. When people think of treaties, they think of, I suppose, colonial era agreements. They think of parties for the first time meeting each other, perhaps in small group of Crown representatives, perhaps, or newcomers, colonialists arriving, landing on a shore and meeting a small group of Indigenous peoples and coming to some agreement in the first case, in a first type of meeting. And certainly these historic agreements are, I suppose, of what people think of when they think of treaty. But a modern agreement is really much more complex, much more technical, much more detailed, and takes a lot of time to negotiate and to develop. And so it's a really phenomenal effort on behalf of the First Peoples, by the First Peoples Assembly on behalf of Aboriginal Victorians, and of course in the state government as well. What I want to do though is talk a little bit about how this agreement compares in sort of content, in process, maybe in stability, and perhaps also as a symbol from some other treaties that people may have in their mind, either historic agreements or modern agreements. And so I think just the first point of the content one, Cheryl mentioned this, that the treaty itself is about 35 pages and the bill is more than 200 pages. It's a very detailed agreement, right? Historic agreements usually operate at the level of principle rather than detail. The Treaty of Waitangi consists of a preamble and 3 articles. Colonial era agreements in North America were similarly at the level of principle rather than detail. You see that the very first treaty between the US Republic and First Peoples is the Treaty of the Delaware Nation of 1778. And that consisted of 6 articles. That was the entire length of the treaty. Primarily, it's framed around this idea of securing peace and perpetual friendship, the idea that they wouldn't go to war with each other, that they would maintain trade, and they would contain ways to mediate disputes that might arise between the 2 parties. But really, it was understood that it was a much more relational document, that the treaty would be lived and would be an enduring, iterative engagement that would only survive as long as the parties wanted it to survive. And the detail would be worked out later if and when problems emerged, and it would be kind of referred back to that principle, I suppose. It's the same in Canada as well, just above the border. Those early treaties were really around level of securing peace and friendship, of trying to work out how to secure trade routes, and just basically an agreement that when there will be disagreement, that they'll meet and discuss and have a parlay, I suppose, of getting together and chatting and working something out. Now, of course, modern agreements do operate at the level of detail, but they do have reference to the broad principles, and you can see that in this statewide treaty as well. It talks about the idea of a shared future. It talks about building a better relationship between the state and First Peoples, and building a better Victoria for all as well. So that principle is important, but I guess that's done through the detail that Cheryl has gone through a little bit. There are modern agreements that are continually negotiated in Canada today, and they again have kind of look very different from this treaty. I sort of see this treaty as institutional, interactive, and iterative. It's institutional, and it sets up processes and organisations and structures in order to have an interactive and relational discussion between First Peoples and the state. And it's iterative in that it's expressly framed as being the first of many statewide treaties and, of course, traditional owner treaties as well. So it really is a starting point for how we can start thinking about this relationship in a treaty sense. In Canada, because the treaty process has been going on for a lot longer, there's a historic understanding of, well, there's a long history of treaties as well, there's a better understanding of what treaties are, what they look like. There's also a very different legal and political culture or different contextual framework. The treaties that have emerged are much more nation to nation. They're perhaps more looking at what the traditional owner treaties might look like in Victoria rather than the statewide treaty. And they are essentially come down to looking at recognising land rights and then governance rights over that land as well. So they involve recognition of broad legislative authority over matters such as culture, land use, economic development, ownership and management of land, environmental co-management, education, language, cultural protection, sort of broad sway of fields, I suppose, essentially recognised as First Nations lawmaking authority over those fields. Now, this doesn't get to that stage, but that's because it's an iterative process. It's the first one. It's at a statewide level rather than a nation level. So it does look very different from those Canadian treaties. I would say also the context is very different. We don't have a Section 35 constitutional protection of treaties. We don't have honour of Crown principles. We don't have a judiciary that is directing government to the negotiating table. And we don't have government recognition that self-government exists. And so this sort of broader or different contextual framework means that the treaties in Canada have been shaped very differently. But as a iterative institutional treaty, I expect that if it continues, we will eventually move down that path as well. I think this is important as well because it's not that this treaty is lesser because it doesn't include a broad swathe of self-government provisions. It clearly has set up in the treaty that this is expected to be subject to negotiation moving forward. And so it's again, an iterative process. But it's important to note as well that the importance or the success of self-government arrangements, I think, really is highly dependent on the design, the operation, the effectiveness of the legal and policy architecture around it. And we really haven't got that yet in Victoria. So this is a process that is ongoing and evolving. And it makes sense to my mind that we don't have that broad swathe of legislative recognition or legislative authority yet. But if the treaty the process continues along, we expect that we'll get there. That's a short summary, I guess, of the content, how it differs from those modern Canadian treaties. I'd say the process also differs as well. If I just note briefly the historic agreements, I'd say modern day courts, if these were contracts negotiated today, modern day courts would rip up most of the historic treaties that have been negotiated in the colonial era. They were marked by duress, undue influence, and often outright fraud. Negotiated in English over a couple of days at best. Their oral promises were made but not recorded in writing. And sometimes First Peoples were required to sign blank documents and the text was filled in later by one of the signatories, right, by the Crown parties. And so modern day historic treaties would have been ripped up. I suppose the process was ridiculous and it was not fair in any modern day, and really at that point as well wasn't fair at that time. Now, Victoria, I'd say not just that it is very different from that process, but I'd say it represents best practice and really expands or extends upon what happens in Canada. So I think this is an area where the Victorian process may have learned a lot from BC, British Columbia, and Canada, but it also has a lot to offer Canadian treaty processes. Cheryl's already noted a little bit of this already, but it's been a 10-year process of preliminary steps, building the necessary architecture and community understanding around treaty. It's secured, it's happened over 2 electoral cycles as well, so it's hopeful that it's been grounded within the community as a kind of a understood priority of government that is sort of at least has some tacit support, if not explicit support. Of course, a long way to go, but I think this is really important in that developing that architecture has helped to allow First Nations peoples within the state to kind of have a sense of what their negotiating position would be, how they can reach that negotiating position, how they can discuss these matters, and have faith, I suppose, that the government is committed to it, that they haven't been spending 10 years putting all their faith in one, or putting all their eggs in one basket for a government to say, look, we're not doing this anymore, let's move on to something else, and have wasted a lot of that time. So I think that process has been really good in building trust, and also building relationships between the parties. And I think this is the key thing, that the benefit of a treaty or the promise of a treaty is a relationship that is different. The settlement, the outcomes are great, of course, but the relationship is supposed to be different because it's all about how you engage and how you deal with problems that emerge in the future. So if the relationship is strong, and then you hope that the treaty will work. And that process of 10 years of developing stronger relationships between First Peoples and the state, I see as really key to the success of the treaty process. I say it's got a lot to offer the Canadian, our friends in Canada, because the Canadian process really was prompted by the courts. The Victorian process has not been prompted by the courts. It's really been a democratic decision by the government to pursue this. But because the Canadian treaties were prompted by the courts, it kind of was kickstarted by government in a rushed manner. The court said basically you need to negotiate these matters. The Aboriginal people have title to this land, and you need to negotiate this to work out how these title questions can be resolved. So government, I think, ran into treaty processes without any sense of why they're doing it or how they should do it. And early agreements like the James Bay Cree Agreement in the 1970s is essentially a unilaterally foisted agreement on First Nations, and it needed to be amended about 15 years later because it was recognised as being very unfair. Now that has changed, and the British Columbia process is the most structured. But again, the Victorian process looks different because of that different context, because the courts haven't been involved, because there aren't constitutional principles that structure the negotiations. They've had to develop all this architecture in a collaborative and relational way, I suppose. So it hasn't so much been the courts putting their thumb on the scales and helping to shape the bargaining position of the parties. It really has been the parties themselves working out how do you do this in a better, more effective, more enduring way. So I think that's been really important. have been working slowly and steadily to develop that understanding amongst themselves and hopefully amongst the broader population of Victoria. I should note as well that even though the state was told, or the Crown was told in Canada, that they needed to start negotiating, or there was an obligation to negotiate treaties and other constructive arrangements with First Peoples, that doesn't mean that there wasn't any political contestation over it. And the process in British Columbia, which is the most significant, I suppose, or most useful comparator here, there were a number of constitutional challenges from people who didn't support the treaty process on both, I would say, well, on both the First Peoples side and on the state side, saying that this agreement should be unconstitutional because you can't possibly recognise First Nations lawmaking authority in contemporary Canada. And I know that I expect that there'll be challenges to the statewide treaty as well when it is finally passed by Parliament, or the bill is passed by Parliament. In terms of the treaty as a symbol, I think again, the treaty is always about trying to make redress for past injustices and develop a shared future, a shared framework for engagement moving forward. That's true of historic agreements and modern agreements. A question that I often get asked is if those historic agreements or those colonial agreements were so unfair or inequitable and the government never honoured them anyway, why did First Peoples hold on to them? Why do we care about them? Why should we fight, why should we give any respect to these pieces of paper that were ignored? And the answer that I've been told from colleagues in Canada, First Peoples in Canada, is essentially that they see them in covenantal terms. It's a tripartite agreement between First Peoples with the Crown and also with the Creator. And so in that sense, they see that it remains in force even if one of the parties, the government, has tried to act otherwise. And I think it's also important to note that even if the Crown or the state is not honouring the treaty, it remains, those historic agreements remain representative of a particular type of relationship, and they also recognise the inherent rights and status of First Peoples. And so they're very important in that sense as well. In Canada, at least, that is carried through to the modern agreements. And you see that the Nisga'a Treaty in the late 1990s and early 2000s, the chief of the Nisga'a Nation, Joseph Gosnell, at the time the treaty was signed, talked about this was a way of recognising Nisga'a status and inherent rights, but also a way of becoming part of Canada. And so the metaphor that's often used there is that this is a marriage, not a divorce. It's a way to build better relationships again between the Crown, between the state and First Peoples. And the idea again that this is the most honourable way to resolve issues between the Crown or between the state and Indigenous peoples is through negotiation, through the political processes, rather than through lawsuits, rather than through protests, rather than through other action. It's through negotiations, it's through sitting around a table, because that creates the most enduring and most helpful long-term solutions. And I think you can contrast some of the very generous comments by the Nisga'a Nation at that time, the idea that this is a way of becoming part of Canada, with the treatment that the bill got in the federal parliament during the debate in the 2000s. There were more than 400 proposed amendments to the bill by opponents. Some proposed to gut the bill entirely, and others to remove commas or add full stops. And it took more than 2 full days to vote on all of the amendments and to negative them each time to defeat the amendments. And sort of very kind of petulant behaviour, I suppose, by opponents of the bill. And when the bill finally was passed, there were members of the Nisga'a Nation in the gallery, and they started to sing the Canadian national anthem to celebrate, right? So this is a very different relationship to how people see the treaty. Is it a secession document? Is it a self-government separating document that is often seen as the criticism I read by the IPA and others in the last couple of days? Or is it a way to become part of Victoria in a more fulsome understanding of what Victoria is? I should say, of course, that's not to say that modern treaties are always seen as positive. In Canada particularly, many First Nations peoples criticise the process as a way of subjecting themselves to the Canadian state. Even though it's quite a broad swathe of legislative authority, it's often subject to federal laws, or the Crown is often the final decision maker in certain areas. So while it's significant, it's certainly not, I suppose, self-governed in the sense that a state would operate on, right? It's operating within a state in a more autonomous way, but certainly still within a state. There's been criticism around the language in the treaty processes in Canada around ceding rights. This has changed in the last few years. I think there's a really interesting paper by Johnny Mack, who is a First Nations scholar at UBC in Vancouver, who talks about it's a very personal and thoughtful piece exploring his opposition to his nation's modern treaty. And so I encourage people to reach out, to read that. I can share that link to that in the comments, but it's a really personal exploration of how he sees the treaty process, despite the rest of his nation having recently voted to support the treaty. I should say also, a lot of these processes take a long time to negotiate. 15, 20 years is common in Canada. It's sort of striking that this treaty in Victoria was negotiated in under a year. Pretty unusual. My hope is that doesn't mean because it's too modest. My hope is that it's because it seen as an iterative, institutional building, interactive treaty that is aiming to set the foundations for future treaties. That's certainly the language in the bill. That's certainly the language in the agreement. But remains to be seen. And I think I might come up to my time. I might just end up by saying I think it's also important to consider the stability of the treaty. In Canada, the treaties are constitutionally protected under Section 35 of the Constitution, so it's very difficult to unilaterally amend it. It's still possible to infringe it by the Crown. They can go through a justification process to explain why they need to infringe the treaty. So the Constitution is protected, but they're still subject to parliamentary change in places. In New Zealand, Aotearoa New Zealand, the Waitangi Treaty is an international agreement, but so it only has legal force when enacted in statute, and those statutes can be revised and amended as well. So it's subject to change. In Victoria too, the treaty, we don't have constitutional protection, right? And there doesn't seem to my mind in the treaty to be any attempt to entrench it in any way. There's no manner of form provisions. There's no attempt to kind of rely on doctrines that don't quite exist in Australia, but could be useful, like the doctrine of quasi-constitutionality. So it's kind of just a piece of legislation that is part of the treaty that can be revised by a future parliament, by a future government. So there isn't really any legal mechanism to prevent that. Maybe that is just because we don't have a good mechanism available in our constitutional framework at present. I think, though, the idea being that a treaty will only endure as long as the relationship is strong. And so if the Victorian community want the relationship to be strong through a treaty, then that's the best way to keep it long-lasting. Legal mechanisms can't really help that. They might be able to prevent it at the margins. They might be able to impose a larger political cost on a government to trying to amend it. But really, it's got to be owned by the community for it to have a long-lasting, enduring fashion. The hope, again, as an iterative process, is that once this treaty is passed and embedded and becomes part of Victorian law, part of the democratic life of Victoria, the Gellung Warl is supposed to be, that it becomes part of the furniture, and then we move on under a new accepted norm of how governance takes part, and we can continue to develop that over time. But it remains to be seen. That one's impossible to say for now. It kind of relies on that broader, kind of relies on it surviving over the next 3 or 4 to 5 years, in my view. I do have some stuff to talk about the Indigenous representative bodies more broadly, or in a comparative sense, but I might leave that to the Q&A. Stop there and let Ruben talk, because I know we're all looking forward to hearing his personal experiences about negotiating the first treaty in Australian history. Thank you.
Thank you so much, Harry, for putting all of that in its broader international context for us. I'm now very happy to hand over to our third speaker, Ruben. Over to you.
Nyata, hi everybody. I'm joining you from a bit of a peculiar place here on the lands of the Wurundjeri peoples. I'm actually in one of the libraries at the Victorian Parliament House, where I spent the day yesterday being able to speak on the floor of Parliament alongside my co-chair Ngara Murray, and then listening to the debate on the debate around this treaty bill. And I'm here today to be able to pop in and continue to listen to that debate and have the important conversations with the politicians as part of this. It's an unusual space to be coming to today, but very much looking forward to sharing this conversation. And it was great to be able to hear from Harry and Cheryl there to know that people have understood what we've been trying to do. It was great hearing their analysis and reflections on the work we've done so far. And as we dive into this and give you a bit of the story from my perspective, just want to really recognise the powerful legal team and the legal support we've had on our end from the Assembly. In particular, our in-house legal support. We've just had a wealth of expertise from our end, and then also from our external legal support. And in particular, I want to shout out to Ken Hayne and Tim Goodwin, who have been really powerful resources to us in this process. In terms of this actual first statewide treaty itself, I think, as has been mentioned by the previous speakers, and it really is critical to reiterate, is the context of this statewide treaty. And you can even step back and look at the 2018 treaty legislation. And if you look through that with kind of fresh eyes, you'll note that there's no reference whatsoever of statewide treaty. It wasn't necessarily even contemplated that there would be statewide treaties when that legislation was passed back in 2018. And so this statewide treaty is almost an afterthought within the process. I think there was an idea that potentially it was just going to be the traditional based treaties, which we are seeing continue on a process already in place for those. But we as the Assembly recognised very early on that we wanted to take this hybrid approach of having both statewide treaties and traditional owner treaties. And so that's been really powerful to see this component of it progress so far, but also just highlighting that fact that this is intended to be the first statewide treaty. And that's really, really important context, because it was never intended that this first statewide treaty be the all-encompassing idea of what treaty is. We totally recognise that for traditional owners, their treaties are going to be the ones that have a much greater focus on access to land, on access to water, on cultural rights, on language rights at that local level. And that is the right place for those rights to be activated and to be advocated for at that traditional owner level. At the statewide level, we as the Assembly, the democratically elected group of traditional owners from all across the state, chosen by our communities, whether that's within the regions where we have our elections for our regional representatives, or within the traditional owner groups selecting their own representatives, we are here to be overseeing this statewide treaty process. And at its heart of the work we've been always pursuing in this process of statewide treaty has been around self-determination, of enacting those key principles of self-determination, particularly as they're articulated within the United Nations Declaration on the Rights of Indigenous Peoples. And at its heart, it's about ensuring that First Peoples can make decisions about First Peoples business. That's really what has led to this key elements of this first statewide treaty. And the overall concept that we're putting in place is this idea of the Gellung Warl, the tip of the spear. And to my mind, when I think about the Gellung Warl and what's being created through this, is essentially the Gellung Warl is a cleared landscape for treaty. It's kind of stripping back the concrete that has come into existence and stripping that back to a cultural landscape within which sits the ongoing First Peoples Assembly, within which sits the Nginma Ngainga Wara, the accountability mechanism, and the Nyerna Yoorrook Telkuna, and then other elements we might add in that sits within this Gellung Warl cleared landscape. And I think that's a useful way of looking at what we're creating through this first statewide treaty process. And a key rationale for kind of progressing this work in that way was realising that over several years now, we'd seen governments with seemingly good intentions pursuing this agenda of self-determination, but it was a very constrained notion of self-determination because it was constrained by the limitations of government agencies, of government departments, of government boards. There was only so much that government could do to transfer across power and responsibilities for First Peoples. There was always this need for a final ministerial oversight of a final checkbox where ministers had to undertake some form of function. There was never really a mechanism for government to completely transfer across to a First Peoples entity the ability to run its own business. And so that's what we've been able to create through this. And a key example of that would be the creation of the Victorian Aboriginal Heritage Council, which was established through legislation back in 2006, which at its time was a really powerful example of the extent of what government could do around self-determination, where it created this council of Aboriginal people who were given the authority under legislation to determine registered Aboriginal parties. Who are the right people for speaking for different areas of country? Who are those traditional owner groups? And that was a role given to that Victorian Aboriginal Heritage Council. But ultimately, the members of that Victorian Aboriginal Heritage Council were appointed by a minister. So it still sat within this framework of the government process. And so what we're seeing now is, and through this first statewide treaty, is the ability for an entity like the Victorian Aboriginal Heritage Council, rather than the minister being the one who ticks off who those members are, it's a First Peoples-led entity that ticks off that representation. And so that's where we're seeing that shift, where we're being able to snip off some of those strings that were still left behind, where government did have good intentions around self-determination, but weren't actually able to implement because of some of those limitations. And the creation of Gellung Warl through legislation enables greater self-determination in that it now creates this entity that can take on board the risk and the responsibilities and still has that oversight in terms of IBAC and the Ombudsman and those key features to ensure there is that accountability, but it enables First Peoples to actually truly lead in their own space. And that's a really powerful shift in the dynamic that we're seeing through this first statewide treaty. And to me, really important when we're looking about what we wanted this first statewide treaty to achieve and the various powers and functions of the Gellung Warl and the future Assembly, there were two important components to me from my perspective. there was creating these future entities that had the ability to do certain things, the ability to make decisions on behalf of First Peoples. So it was capable of doing that, recognised by the state of being able to do that. And then also some tangible examples of what that might look like, so that over time we could continue to build on that. And that's key part of describing this as the first statewide treaty, is that we've kind of created that capacity. We've said here are some initial starting points, which, for example, for this first statewide treaty involves around the ability for the future First Peoples Assembly to make guideline rules around the confirmation of Aboriginality process, particularly as it relates to the third prong of the three-part test, but a way to make sure that if we're talking about how a person is accepted by their community as an Aboriginal or Torres Strait Islander person, that it's First Peoples that can determine what that process should look like. So that's a really powerful, tangible example of the types of rulemaking that this future body can make. And then there's the capacity over time to add additional rulemaking powers, additional standard powers, additional guideline powers to that body. So those two components are a really important part of that process. The ability for it to do X or Y, and there's some tangible examples of that as a starting point that we could then continue to build on over time in future negotiations. The other thing I think that's really key in the approach we took for this first statewide treaty is that there's not one single thing we're kind of hinged on, that yes, this is the key crux of it that enables us to achieve all the different things we want to do. It's a multi-pronged approach. It's looking at a whole raft of areas where government intersects with First Peoples and saying across all those different areas, how can we just tweak and adjust little things in the way that government normally does its business to ensure that there's that First Peoples lens and First Peoples ability to influence and get better outcomes for First Peoples. So really seeing it as that multi-pronged approach is really, really critical. And being able to build on and enhance and leverage off existing conventions, existing processes. So lots of instances where you'll look through the bill and look through the legislation, you'll see that it's taking on the form of existing things that might happen in other areas and putting a treaty lens on those. So it's just enhancing and building upon those existing conventions, which we think is a really useful way of tapping into those processes and ensuring that we can get the best outcomes through that without having to go and create entirely bespoke new things, which there are levels of risk around that. It's about building into the existing infrastructure, but with a different lens, a different approach. I think importantly too, when we are talking about the treaty and the bill, to recognise that from our perspective, the treaty has primacy. The treaty is the agreement between us and the state, and the bill is a flow and effect of that. It's a result of that agreement we've reached between ourselves and the state. And so the treaty is the overarching document. The bill is an activation of commitments made through that treaty. And as I said, that's really important from our perspective. Another key component of the conversations we often came against when we were talking about our aspirations for this was the limitations of what we could do, and this concept of parliamentary sovereignty, which I can honestly say I hadn't heard much about before till I took up this role, and now I can say I've honestly heard it far too much, but being very mindful of the limitations of what one parliament can do in terms of binding future parliaments and making sure that we were doing everything we could to achieve the outcomes we wanted, but having to respect that process and being mindful of the limitations that existed because of that parliamentary sovereignty. And I think it has been recognised by some of the analysis done so far, that I think we've done a pretty good job of trying to approach the limits of that, but obviously not go past it, but get as close to that as we could to ensure that we were getting the best outcomes for First Peoples, but respecting that parliamentary sovereignty and respecting that we're having these negotiations within this Westminster system, and trying to transform that as much as we can within those limitations. The other component I just wanted to touch on before I finish my piece here, and keen to get to the questions and answers as well, was just the recognition that whilst we've had the First Peoples Assembly in place now since 2019 as the democratically elected group of traditional owners from all across the state, and we're now seeing that shifting from technically legally as a corporation now into this statutory body, from an Assembly perspective, we see that that's not the existence of the Assembly. The Assembly doesn't only exist as a company. The Assembly won't only exist as defined by the statute. The Assembly exists on its own right. It's just currently being embodied by a corporation. And as we transition into this statutory body, it will be embodied by that statutory corporation. But we don't only exist in that way. And that's a really important assertion from our perspective as First Peoples, that we have the ability to represent ourselves regardless of whether any statute says we can or we cannot. We are here practicing our business and representing our people. And it's great to be able to do that through the mechanism of a statutory corporation, but we exist independent of that. And that's our right to assert that, which is, I think, a really powerful manoeuvre from our perspective. So hopefully that's given everybody a bit more of an insight into the processes we undertook for this first statewide treaty, but keen to be able to open up for some questions and comments.
Thanks, Reuben. That's terrific. And thanks, Cheryl and Harry and Reuben, all for your different takes on this and how they've fitted together. It's very interesting. We do have a few minutes for, in fact, I think we've got more than a few minutes for Q&A, and I will come to the questions that have been posted in the Q&A box in a moment, but I just wanted to hand over to my co-chair, Luke, as a provocateur with a question. And then I'll come back to some of the questions I've got lined up for me in the box there. So over to you, Luke.
Thanks, Melissa. And I think my provocative question goes equally to all of the speakers in different ways. So we've heard critiques from certain elements in the community, and the state opposition has said publicly that they would intend to repeal this legislation should they ever win an election. My question is around that. Would mere repeal of this legislation be effective to undo the practical consequences of treaty and treaties and all that follows from that, since treaty may have an existence quite separate and apart from the legislation? And what would it mean to unwind or just merely repeal the legislation? Is that effective to undo that? And do some of the critiques made really characterize the legislation and treaty properly? I know Harry sort of described it as misconceiving this as divorce rather than as marriage and coming together. So that's my provocative question.
I'm happy to have a crack first. Yeah, I think it's a very interesting question. And as I said, from my perspective, the treaty is the overarching document. It's the overarching agreement between ourselves and the state. And so there are multiple different aspects of that treaty that are independent of the legislation itself. And so those would, they are unaffected by a repeal. And I think there's a level of political agreement in that process that I think transcends any legislative processes. But there are practically some key components that only do exist within the legislation. And so on a technical side, I think that's a more technical question that I'm probably not as well placed to answer as the others. But I think recognizing that there's a distinction between the treaty and what is detailed within the legislation is a useful distinction to make. And also, I think the agreement between the two parties, between the government at the moment representing Victoria and us as First Peoples representing First Peoples, that agreement can't just be broken by rescinding a different piece of legislation that doesn't involve us as part of that process.
Cheryl, did you want to add in?
Yes, I think it's an interesting question, and I completely agree with what Reuben's just said, and in fact the burden of his remarks. It really struck me in reading the legislation and then looking at the treaty, how the treaty was not dependent for its existence and its significance on the legislation. There are some respects in which legislative action is needed, obviously, appropriating funds, for example, but in other ways the legislation is just giving form to practices that could be carried out anyway. And you don't repeal the treaty by repealing the legislation. I mean, you might even say, how do you even repeal a treaty? The treaty is now a fact. This agreement has been reached between the First Peoples of Victoria and a legitimate government of Victoria. So it exists. And I was very interested in Reuben's point also about how the Assembly exists. The Assembly is a representative body for First Peoples in Australia, and it will be whatever is said in legislation. So there's a sense, it's a very interesting sense in which legally, I think it's impossible to wind this back in any complete way, although it's possible to make a mess of it. But practically it's impossible as well, because so much has happened to bring Victoria to this point, and that's not going to go away.
I think I agree with those 2 points. I like that from Reuben and Cheryl. I suppose the thing I think is that one difference, again, from the Canadian model of treaty processes and legislation, they also have legislation that implements the treaty in order to give it legal effect. The way they often do it is that it's a schedule to an act. This is different, right? And so the treaty in Canada, those modern Canadian treaties are often 200, 300, 400 pages long, but the treaty bill itself is relatively short, just saying that this legislation implements the treaty which is contained in the schedule to this act. This is a different approach where the treaty itself is relatively short, although it's still more technical and detailed than the historic agreements, but the legislation itself is very detailed. So it's a difference in approach. The treaty, in my sense, my understanding is that the Treaty Act could be repealed, and that would mean that institutions like the Gellung Warl would no longer have the legislative backing for them. But the treaty would still remain in effect. But I see the treaty as a contract between the state of Victoria and the First Peoples Assembly, and the government can revoke a contract or terminate a contract if it chooses to do so. Often you'd usually have damages. My understanding is that governments don't normally have to pay damages if they terminate a contract. But if the state changes, a policy change happens, and a new government says that we have, a doctrine of executive necessity comes in and say we no longer want to abide by this contract, that they could terminate it. I think that's a matter of law. They could, but I feel that'd be very difficult to do politically, and the symbolism of the first treaty being repealed or revoked or terminated by one party unilaterally, I think would be very challenging. And I think that is sort of, even though this agreement itself, as Ruben said, there's reasons why it's not as, doesn't look like a traditional modern treaty in Canada in terms of jurisdiction. The symbolism of calling it a treaty, I think, is very important because it helps to build that, buttress it or fortify it with support, which makes unilateral termination hard. But my sense is that it could be repealed. It'd be a massive mess and it'd be very difficult to do so, politically, but legally I think it could, because it is a contract that is then supported by legislation. Not all of it is supported by legislation, but the contract could be terminated.
Thanks, Harry. Ruben, did you want to come back around and add anything, or we're okay?
No, I think we're all good there.
All right.
Melissa, can I just say, though, I think it's really important that in talking about the treaty, people don't get overwhelmed by the possibility that somebody might wind it back at some stage. It's an achievement in its own right.
Yes.
It needs to be understood and owned by the people of Victoria.
Thank you. I'm going to take some questions from the floor, although they're from the internet. So the first question I'm going to raise, Ruben, you might have a thought on this. The treaty bill creates some new duties for public authorities and embeds truth-telling and cultural governance across the government. Was there discussion about the plans to build capability and capacity in the Victorian Public Service, whether it's through education, cultural, leadership, all those different areas of development? Because it seems that it would be important that the Victorian public servants genuinely understand the obligations, in alignment with their duties under the Charter for Human Rights and Responsibilities.
Yeah, absolutely. And there's two kind of considerations of this. There's one within the bill itself. So there's an amendment to the Public Administration Act within the bill, which talks about the obligations on public service body heads to support the development of a culturally capable workforce and recognise the role of public service bodies within the treaty-making process. And then within the actual treaty itself, it talks about the development of performance goals for those public service body heads. So there's both the aspiration of what they should be doing, and there's a monitoring process to make sure it's actually happening. So that was definitely a strong consideration. And a key thing we heard for many of the work we've done, we've referenced what some of our Indigenous colleagues across the globe have done. And that was a key learning from Aotearoa, that yes, you may well have the political leaders saying this is something that has to change, but so much of it is dependent on the delivery, the implementation by the public service, that if you don't have the buy-in at that level, it can really struggle. And so making sure there was that obligation on the public service to educate and raise that awareness and understanding, we recognised as a really key component.
Thank you. And this is another Charter and Victorian question. And I think, Harry, you might think about this first. You made the point that the treaty bill doesn't have constitutional status. And do you think there are any lessons to be learned from the experience of the Charter of Human Rights in Victoria in terms of how the legislation is regarded and incorporated and treated by government? We've had the Charter for 20 years and it hasn't been repealed, but it hasn't been amended, and there's a question of relevance and upkeep, and in contrast, say, with the ACT Human Rights Act. So do you have any observations, and Cheryl and Ruben as well, on that comparator?
Yeah, I think it's a good question. Thanks, Kylie. Thanks, Melissa. I think the treaty says, I mean, as I've said, treaties are relational documents, right? They're intended to be set the framework for parties to engage over the long-term ways to develop a better way to work together. And so they should be updated, right? They're not a set and forget document you sign and you move on and never talk to each other again. And so I think the treaty, if I recall correctly, if Ruben can correct me here if I'm wrong, but I think there are provisions in the treaty and in the bill setting out procedures of how it will be amended and updated. And so there's supposed to be regular processes, and this is a procedure that is different from ordinary legislative change, where Parliament can the government can just introduce a bill to amend the treaty. The treaty bill is only allowed to be amended formally, at least according to its own terms, in accordance with the procedure, which says there needs to be discussions and consultations with the First Peoples Assembly as well. So it is expected that it will be I expect it to be updated over the course of future years. So it won't be sort of set and forget, perhaps like the Charter might be, if that's how I understand the question. The other point I think that is important is the Charter has a primacy clause that says that other legislation needs to be interpreted in accordance with the Charter, and they can't necessarily be implicitly repealed or impliedly repealed. I didn't see a primacy clause in the treaty bill. So another concern I may have is that legislation that's passed post-treaty won't necessarily, it could sort of implicitly repeal legislation in the provisions of the treaty bill. It's hard to imagine how that might happen in the way the treaty bill is structured and drafted. But that's something I think is different and important, that the Charter has a primacy clause over future legislation, whereas the treaty bill doesn't seem to at this stage. But again, hopefully, I just may have missed that.
Thanks, Harry. Ruben, any thoughts on that? Did those considerations come into your discussions?
Yeah, no, I think Harry captured it all there, and yeah, there's definitely the scope to adjust and amend and review these processes as necessary. And in terms of any kind of future legislation that might have an impact, we've got those duties to consult, and that ability to comment and influence those sorts of things is kind of been factored into those components. But yeah, it's a complex process to try and unpack all those various different loopholes within those processes.
And listen, I mean, instruments live in different ways. I mean, we know the problems that the Charter's encountered. One is the interpretation of key provisions of it by the High Court, and the other really is its dependence on the legal profession to take it up and run with it when there's an attempt to actually put it into effect. And I distinguish that from whatever impact the Charter might have at the bureaucratic level when legislation and administration is being forged. Seems to me that the treaty has got an entirely different life force. It's going to be activated in all sorts of ways right across the state if it's complied with, and there are ways of ensuring compliance or monitoring compliance and publicising non-compliance. So I just think they're very different instruments, novel though each might have been in its own time.
Okay, so I have a legal question and then a sort of political question. So the legal question is, the Gellung Warl in its form seems to us to look like a new form of public institution. It's not something we're familiar with, and it hasn't manifested in that way before in Australia. Is there any comparator that we would recognise in existing either Australian frameworks, or Harry, is it like something else that we see overseas in that it's advisory, inquiry and accountability, or it's sort of a three-part story there. Ruben, was there a model that you were working off that looked like, you mentioned New Zealand, but is there a model, or is it just something completely unique to Victoria?
I would say that it's a hybrid of many different things. We've been able to look at various different models, both in terms of First Peoples models, but also local government processes, and say, okay, well, this kind of works as a way of approaching business, that we could take some parts of that and add it together, and take some other parts of that and add it over to here. So it's a conglomeration of various different components, of which there's nothing like it in its entirety. But if you look at each particular component, you might say, well, that component is quite similar to X or Y, or that approach is quite similar to X or Y. But yeah, there's nothing that is all of those bits all together.
I'd agree with that. I haven't seen anything like this in other models. I think it kind of, again, reflects the context, right, as well. The accountability function within the Gellung Warl is sort of partly supposed to be a mechanism through the closing the gap arrangement, right, as well. And the truth-telling one is an ongoing form from the Yoorrook Justice Commission, and so it reflects a particular context. But you look at, again, processes elsewhere, truth-telling is often seen as an outcome of treaty as opposed to a precursor to treaty. And so I think that's a difference that's happened in Victoria, which has helped to inform the way that this body is being developed, and again is different from other places around the world. I haven't seen that, so it's great to hear from Ruben that there has been models from all over the place, not just within First Peoples organisations.
Cheryl, any?
No, I don't know of
insights?
any example either, but again, it's not surprising. It's performing a function that hasn't been performed before in the Australian context. And if we've come up with a novel collection of approaches that works, that's great.
So now I'll ask my political question from Scotty, which is, appreciates the insights from the panel. Thank you. Ruben, are you willing to speak about some of the key issues currently under debate in Parliament? You're allowed to say no if it's not appropriate, but...
Yeah. Well, I mean, I'm listening out through the walls to hear what the current debate is right now. But yeah, it was interesting yesterday to hear the various sides and perspectives on this. Obviously, we've been having conversations around this process with all sides of politics throughout this process. And whilst we did have bipartisan support from the previous two pieces of legislation that passed through Parliament related to the treaty-making processes, we currently don't. But there's obviously a large majority for Labor within the Legislative Assembly, and then within the Legislative Council, there is the balance of power sits with the Greens, who are very supportive of this process, and then with the Legalised Cannabis Party and the Animal Justice Party, both publicly and privately expressed their support for this process. In terms of the actual nature of the debate, the opposition have come out with a proposal from yesterday about their position on these things. I'll just note that it was without any consultation with the democratically elected group of First Peoples, so I'll let that speak for itself on their proposal.
Thank you. This will be our last question from Teresa. It's common in legislation in New Zealand to have a provision that requires the Act to be interpreted and persons performing functions to do so in a manner consistent with the provisions of the Treaty of Waitangi. Is this something you anticipate or are aiming for in the future?
Yeah, I'm happy to have a first crack at that. I think all the work we've done within the treaty making process has these overarching principles that we've been kind of bound by through that. And that's intended to be an ongoing consideration. I have these principles stuck on my office wall, and they have guided me through this process the entire time. And it's the intention that those principles, including the concepts of self-determination, transparency, accountability, mutual benefit, are things that continue to guide all aspects of the treaty relationship moving forward. And so that's kind of ingrained within all aspects of the treaty making process here in Victoria. And I think that so far has held us in good stead, and I expect it to into the future as well.
Thank you. Any final wrap-up words from our speakers? Any final reflections or closing words you'd like to leave the audience with?
Just to say well done to Ruben. Sorry, Cheryl. Ruben and all the negotiating team, terrific work. It's crazy to think about. This has been obviously long-standing aspiration. We've had debates for more than 50 years in Australia about this, and it's phenomenal to see it get up at this stage, right? I would love to hear your reflections, Ruben, on the last couple of years that you've been involved in, and even sort of thinking back to if you ever really thought we'd get to this stage 15 years ago, even.
6 months ago, even. It has been an incredible process. And I think just the way we framed it to say, well, this is just the first step and there are many other components. That's what's made this achievable from our perspective, and being very mindful of the time frame that we do have a state election coming up next year in November. The last kind of comments I'd leave people with, that if you didn't get a chance to watch the speeches from myself and Ngara yesterday, I really encourage people to go and check those out. They're on the Parliament of Victoria YouTube site. And also to make sure, if you haven't, obviously, as we said, the bill is a big document. The treaty is a sizable document. The preamble to the treaty is something that we spent a lot of time and effort on to really capture some really key components of what we're about here. And I would encourage people to read through that, sit down and read through it with your family. I think that's a really powerful way to understand what we're trying to achieve here in Victoria, and for everyone to take great pride in what we're achieving here in Victoria.
Thank you, Ruben. And Cheryl?
Yeah, I think what Ruben's just said is very important. Also, what he said earlier about the principles. I hope that when the treaty comes into effect, which I think is expected around about May next year, there are really appropriate celebrations and celebrations that draw attention to the really very accessible parts of this package in the preamble, in the principles, in the objectives, things that people can relate to and hopefully remember and put into effect.
Thank you. Well, it does feel like quite a momentous moment, and it's been a big week, and particularly for Ruben, a very, very big week. I just want to remind our audience that we've put some resources into the chat. So maybe Scott will drop them in there again, or maybe we won't have time, I'm not sure. But we do have lots of resources. The First Peoples Assembly has terrific resources, especially for allies and supporters. So there's space there for people to get involved in different ways. And there are at least 2 more webinars coming up next week from the First Peoples Assembly that speak to individuals and people who work in organisations about how they can get involved. So I urge you to check out the material at the First Peoples Assembly site. There's also now treatyvictoria.gov.something. You'll find it by Googling. And also the Treaty Authority itself has materials there. So there are lots of resources out now. And this is the time we would urge people to get hold of those resources, share them with people. As Ruben said, have a conversation and start talking to people about this, because I imagine that we're about to move into a phase of massive disinformation, and it would be helpful if people carry with them, you know, some factual knowledge and some decent ways of conversing about this important development. And it's important for all Victorians, not just for First Peoples in Victoria. So I urge you to get involved at that level or further. And so it probably is time for me to, yes, someone's just reminded me also have a look at the Yoorrook reports and the materials on the Yoorrook website, which has just terrific explanation of why we're here and how we got here. But now I'd like to thank our audience for joining us over your lunch and spending time with us hearing and thinking about these issues. I want to particularly thank the Castan Centre team, especially Gina and Scott, who are with us online today, controlling Luke and I and turning things on and off, which it's very important to have someone to drive the bus while you're being tour guide. But particularly I'd like you to join us in thanking the speakers, Cheryl, Harry and Ruben. And Ruben, a real special thank you, because this week we didn't really realise that this week was going to be quite the week that it is, but we really appreciate having you with us and the work that's gone in behind the scenes from your team as well. So if you can join me in I don't know how, but raise your hands or send out good wishes or send Ruben an email or something. But thank you very much all for your participation. It's been a really worthwhile seminar. We will have the recording. I've got at least a number of raised hands that I can see waving at you. We'll have the recording available when we can. But thank you all for joining us. And I think I'm going to, Luke, any farewells and thank you from your side? Otherwise, I'm going to close the ceremony.
Thank you to everybody, and thank you to Melissa.
All right. Well, with that being said, we're going to turn off the Zoom, and we wish you all a great afternoon and go well. Thank you.